Okay, guys. So, welcome to week 9 of IP Law. And this week we have, who do we have presenting? We have Carla, we have Brendan, Jacob, and Catherine. And they will be presenting on, as you can see, they've started their screen sharing. They will be presenting on Evergreening
in Australia with reference to the...
Yes. So without further ado, who would you like me to hand over to? Carla?
Catherine will then compare the Australian position to other international positions on Evergreening and conclude the presentation.
Okie dokie.
Evergreening is a colloquial word used to describe the use of follow-on patents in pharmaceutical industry to extend the life of a patent or to delay the release of generic versions. In doing so, this increases the profits of the patent holder by allowing them to charge premium prices while they have a monopoly without the competition of cheaper generic versions. Modern Evergreening originated in the US through the Waxman-Hatch legislation in 1984. In an attempt to balance the introduction of generic drugs after a patent expires, to bring the price of drugs down for consumers, and to protect the patent holder's exclusive rights, to create enough profit from their invention that would encourage research and development. The legislation provided for 30-month stays on the release of generic drugs, while a claim against the release of generic equivalents by the patent holder was reviewed by the courts. These stays are very profitable for the patent holder, and tweaks to the drugs, including methods of use and delivery systems that form the basis of the claim for a follow-on patent, could be even more profitable if they were found to be a viable reason for the court to allow an extension to the patent. For this reason, some factors of a new drug, like delivery systems or minor modifications of the product, are held off until the patent has expired or near the end of its initial term, and then released as a new inventive step to increase the life of the patent. In Australia, Evergreening was not given much attention by the public or the courts until 2004, when the contents of the Australian and US Free Trade Agreement were debated in the Parliament and in public forums. There was a fear that there would be a watering down of the requirements needed to gain a follow-on patent. In its submission to the Senate inquiry of the Australian and US Free Trade Agreement, the Genetic Medicines Industry Association of Australia stated this evergreening position could lead to long delays or genetic equivalents not reaching the market. The extra process in the bills, including reporting to the patent owner of any request of a generic drug company to springboard, which is to use listed scientific data of a product to create generic forms in preparation of the patent expiring. Extra review processes in registering generic drugs for admission to the PBS would also create delays. The Generic Medicines Industry Association of Australia estimated that if big companies succeeded in delaying generic drug market entry for as little as 24 months, the federal cost for just the first few highest expenditure PBS drugs could be $1.5 billion between 2006 and 2009, and public hospital drug expenditures could increase by 12% over the same period. The legislation in Australia relevant to evergreening is the Patent Act of 1990. Relevant sections in this Act are Section 13, which gives exclusive rights during the term of the patent. Part 3 of the Patents Act, Section 70 to Section 79A, deals with the rules of follow-on patents. Section 70 sets out certain criteria that needs to be satisfied to warrant the granting of an extension to the patent. At least one pharmaceutical substance of the follow-on claim must be within the scope of the patent. Legislation in the Therapeutic Goods Act of 1989 must also be satisfied to gain follow-on patents. Substances must satisfy Section 26 of the TGA and must be listed on the Australian Therapeutic Goods Registry to be able to be patented pursuant to Section 73A of the Patent Act in 1990. There are some important cases in Australia that expose Australia's position on evergreening. Cases such as Boehringer Ingelheim International versus the Commissioner of the Patents. The extension of a patent was rejected as there was no claim in relation to the pharmaceutical substance per se. The term per se, as used in Section 70 of the Act, was interpreted on appeal in the Federal Court to mean by itself. So the substance container with a delivery method was not granted extension as the claim did not encompass the makeup of the pharmaceutical substance. The court found the meaning of per se was described in the explanatory notes when the bill was first forwarded, so an appeal to the High Court was denied. This decision was further clarified in Pre-J Holdings Limited versus Commissioner of Patents. The difference in this case was that the claim was for a method and not a physical device, as in Boehringer. Again, it was found that there was no change in the substances required in Section 70 Patents Act to fulfil the requirements of a follow-on patent. Lohmann Therapy Systems put a claim forward to the Patent Office for a follow-on patent for a bandage that's structural properties to allow controlled slow release of a known drug. The patch was not considered a pharmaceutical substance that was necessary to satisfy the requirements set out in Section 73A of the Patent Act. This decision was never appealed and has made it more difficult to claim something like slow-release tablets as a follow-on patent. However, in Zentis Alex Schaaf's extension to the patent claim, the method of creating a pharmaceutical substance was found to be a vital component of the creation of the final composition, the substance, satisfying Section 70 requirements, so an extension was granted. In Ackle, Bogut, Hassel versus Alpha Farm, an extension was granted to the original patent as the steps to create a new chemical were not obvious and an inventive step was required to do so. In Merck & Co. versus Arrow Pharmaceuticals Limited, the steps to administer the drug were found not to be an inventive step and the appeal was denied. And in Lundbeck versus Alpha Farm, an extension was granted as a new method made a more potent form of the initial patented subject. These cases give an overview of the current position of the Australian courts concerning evergreening in their attempt to balance the risk of the patent holders and the research and development they do while providing affordable healthcare for the public. Next, Carla will be discussing the Gleevec case that has highlighted controversies in relation to evergreening.
Thank you, Brendan. If you can bear with me so I can share my screen. Okay. All right. So like Brendan said, I'm going to be looking at a very important international case, which is Novartis and Union of India. It's a case which was heard in the Indian Supreme Court. The importance of this case is that it deals with the issues of evergreening regarding a drug called Gleevec, and it resonated with a lot of controversy afterwards, both locally in India and internationally. So I'm going to be talking a bit about Novartis, which is a pharmaceutical company that invented and discovered Gleevec. I'm going to be talking a bit about the Gleevec drug. I'm going to be talking about the facts of the case and the issues that were presented to court, as well as the decision that was reached by the courts and the impact of this decision both internally and internationally. So who is Novartis? Novartis is a pharmaceutical drug company that was created in 1996 through a merger between two companies. It is headquartered in Basel, Switzerland, and it has a rich history of developing innovative drugs. Some of the innovative drugs that you are all familiar with is Voltaren and the ophthalmologic drugs from the Alcon line. And of course, the Gleevec drug, which is at the center of the current controversy and at the center of our case. So, what is Gleevec? Gleevec is a chemotherapy drug that was developed to treat chronic myeloid leukemia, which is a form of cancer. So how does Gleevec work? To know more about how Gleevec works, I'll invite you to watch a short video about how it works. Sorry.
Chronic myeloid leukemia is a disease caused by a genetic mutation that gives rise to this abnormal protein molecule. The abnormal protein triggers the bone marrow to release dangerous numbers of white blood cells. Gleevec, the thin molecule shown here in blue, has a specific shape which blocks the active site of the abnormal protein. By binding to the active site, Gleevec prevents the trigger protein from causing release of the white blood cells and alleviates the symptoms of the disease.
After this short video, we are going to talk a bit about Indian IP law. Prior to 1998, patents were not allowed in India. So when Novartis discovered a molecule called imotinib, which is used to treat cancer, it couldn't apply to patent it. So instead, it applied for exclusive marketing rights of the molecule imotinib. In 1998, Novartis discovers another variation of the molecule novatinib, which is called novatinib mesylate. And this new variation of the original molecule, Novartis applied to patent it since India, because in 1998, India had already entered the World Trade Organization and had already signed the TRIPS agreement. But it wasn't until 2005 that India started examining patents. So what is the TRIPS agreement? Catherine is going to talk more in depth about the TRIPS agreement, but just as an overview, the TRIPS agreement is an international legal agreement between all the member nations of the World Trade Organization. It introduced intellectual property law into the international trading system. It helped set the IP rights, the remedies, and the procedures that can be used for dispute resolution. And it is expected from all member nations of the World Trade Organization to follow those procedures and to follow the laws and the contract agreements under TRIPS. And since India is a country that has signed the TRIPS agreement, it is required to follow it. So what is the difference between the original molecule, imotinib, that was invented by Novartis in 1993, and the Gleevec molecule that was invented in 1998, and which Novartis is seeking to patent it? What's the difference between them? This is how the molecule imotinib looks like. And this is how the molecule Gleevec, which is imotinib mesylate, looks like. They are exactly the same molecules, except that there is an addition of a mesylate molecule to imotinib. So we can see it's a slight modification of the original molecule. The Gleevec's patent was rejected in court. The court found that the ingredients for grant of patent novelty and non-obviousness to persons skilled in the art were present. However, the court found that the new drug, is not a new substance, but an amended version of a known compound, and that Novartis had failed to show better efficacy. In summary, the court found that Gleevec has failed the test laid down by Section 3D of the Indian Patents Act. Novartis decides to fight back. On appeal, Novartis claims that paragraph 3D of the patent law is unconstitutionally vague and that it violated the TRIPS agreement. On appeal, the court decides that the word efficacy, which is present in paragraph 3D of the Act, means therapeutic efficacy, and that indeed Gleevec failed to show an enhanced therapeutic efficacy compared to the original molecule, imotinib. And the court decides that there were no violation of the TRIPS agreement. What happened in India? After this decision was reached by the court, there was extensive outrage from the Indian and international media. The international impact was the US trade representatives in 2013 wrote a special 301 report concerning the Gleevec case. And the reason why it was written in 2013 is because the litigation behind the Gleevec case took 7 years to be finalized. And the US trade representative decided that to put India on its priority watch list. Also, there were concerns raised that India is not recognizing the intellectual property law in its dealings with pharmaceutical companies. There were also repercussions. There were also concerns that there would be repercussions on attracting foreign investment into the Indian market, because the pharmaceutical companies, at the end of the day, if they cannot patent the discoveries that they are making with the new molecules of drug, how are they going to have any return on their investment? And it would be an issue for them, a problem for them to actually enter the Indian market if there is no guarantee for them to have patent for their drugs. The controversy that this case has raised was it sparked a debate between, in one hand, balancing public good, which is presenting to the population an affordable form of drug, especially for low-income earners. And we all know that in India, there's a lot of low-income earners, against the pharmaceutical companies' monopoly of prices of medication, because the pharmaceutical companies, at the end of the day, they're spending 20 years investing in research and development to come up with a new molecule to put into the market. And they would like to see a return on their investment into that molecule. So what was the controversy, and how did the world deal with this controversy? I think Jacob now will lead the discussion and will show us more about this debate and how the balance between public good and monopolistic pricing and innovation with affordability.
Okay, thank you very much, Carla. It's very interesting. Novartis made Voltaren. Bit of a heads up, don't rub Voltaren directly into your scalp, lose all your hair. Okay, so PowerPoint. Bear with me. Bear with me. Here we go. Can we see that? I'll take that as a yes.
No, I'm not seeing your screen, Jake.
No? Okay. 1 sec.
That's all good. Take your time.
How about now?
Yep.
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 Fantastic. Seamless. Okie dokie. My segment of our presentation will focus on the competing interests involved in evergreening, where the practice is viewed solely as a profit-generating device for pharmaceutical companies. I will address several questions regarding the debate around evergreening strategies. Does evergreening undermine patent policy? As the principal function of a company is to make a profit, does a patent, that is a temporary grant of a monopoly, conflict with the tenets of competition and consumer law? Specifically, where the patented innovative invention is continually, deliberately renewed to maximise profit. Does this conflict with competition in the marketplace, inhibit the production of cheaper generic drugs, and as a consequence, reduce those in a lower socio-economic bracket gaining access to often life-saving medicines? To briefly recap what has been previously stated, evergreening is the strategic extension of the duration of a temporary monopolistic or market-dominant position by means of IP strategies. In particular, to this workshop presentation, practice patent strategies. These patent strategies relate to pharmaceutical patents and the practice of reformulating claims relating to essentially the same pharmaceutical invention. So the effective monopoly over the substance can be extended after the principal term of the patent expires. An example of this evergreening practice might be filing an application for a new and inventive delivery method or dosage regime concerning the already patented substance, such as in the case of Merck & Co. Inc. and Arrow Pharmaceuticals Limited. To put this in layman's terms, important new drugs are often priced out of the reach of many people in need of them, and these prices remain high until a patent expires. Evergreening appears to favour the profit-making period. Many commentators and industry critics have observed the practice of making minor variations to existing drugs to extend a patent coverage allows the patent to never fall off the branch and, as a consequence, never allow cheaper generic versions of the drugs to be made available. Essentially, an originator company develops a patent portfolio or patent thicket containing numerous follow-on patents surrounding a single pharmaceutical. This can create a barrier for generic producers and competitors. The argument critical of evergreening centres on the balance between patients' rights and patent rights. Here's an amusing cartoon to illustrate that. Patient care or big pharma profits, that's what I break it down to. A common public perception promulgated by the media about evergreening is that it is somehow an abuse or excuse by pharmaceutical companies for further avarice by already unethical monopolistic privilege granted by the patent system. Expanding on this perception are the following major criticisms, if indeed it is the fact that evergreening strategies are not being maintained within the bounds of the law. Evergreening strategies undermine patent policy. The foundation of patent system is the grant of a temporary monopoly to exploit an invention in exchange for disclosure of the technical details of the invention to the public, which optimises public benefit by fostering the dissemination of information and incentivising investment in innovation. Arguably, the extension of the patent-protected market life of a pharmaceutical under the practice of evergreening undermines the rationale of the patent bargain between the patentee and the public. This tweaking something old and calling it new by slightly modifying aspects of existing drugs to obtain further patent protection while providing economic advantage to the originator often offers no new significant therapeutic advantage for patients. It is a requirement under the Commonwealth Patents Act 1990 that for a follow-on innovation patent to be granted, a patentee must disclose an actual invention meeting the patentability requirements under Section 18. If, however, the follow-on patent is obtained by fraud, false suggestion, or misrepresentation, then it may be revoked under Section 138 of the Act. It cannot be stressed enough that the Pharmaceutical Patents Review, together with other commentators, have correctly identified the patentability requirements. It cannot be left to the originator pharmaceutical companies to be the gatekeepers of acceptable patenting behaviour in Australia. In this way, evergreening practices that utilise follow-on patents will not be allowed to undermine fundamental policy rationale that monopoly should be granted for inventions in return for the exchange of information. Evergreening strategies reduce competition and access to healthcare is the next major criticism. Generic pharmaceuticals are drugs equivalent to the brand name drug, the equivalent being the active pharmaceutical ingredient, or API, is the same and are capable of being supplied after the patent for the brand name drug has expired. These generic drugs play an important role in assisting to secure affordable access to pharmaceuticals because these generics are cheaper than the brand name drugs because they have already been developed, tested and approved and don't have to go through the costly R&D process that Carla previously talked about. Consequently, evergreening has attracted criticism for allegedly undermining and exploiting the patent system for the purpose of unfairly blocking competitors. Although in Australia, the Pharmaceutical Benefits Scheme reduces the impact of evergreening practices on public access to competitively priced pharmaceuticals, the availability of generic pharmaceuticals on the PBS saves the taxpayer an estimated $1.4 billion, and that was between 2005 and 2009. Australia's patent system is regulated by a set of robust patentability requirements. Also, there appears to have been struck a reasonable and realistic balance between patenting practices to promote the public interest while achieving commercial objectives. This leads to the question of what are Australia's obligations, both domestic and international, when it comes to IP evergreening strategies. I now introduce Catherine to address this question and conclude our workshop presentation on evergreening. Thank you.
Thank you, Jacob. Good evening, and thank you, Jacob, for your insight into the debate on evergreening. Tonight, I will be drawing on what Brendan has stated regarding Australia's experience with evergreening and our country's stance on the topic. I will then be moving on to international standards, including the Novartis case that Carla has discussed in depth. And finally, I will conclude with our position on evergreening. So Australia has had limited occasions of evergreening that have been brought before our courts. I draw your attention to the case of Merck and Co. and Arrow Pharmaceuticals, which was mentioned by Brendan and Jacob earlier. Now, in this case, a follow-on patent was filed for the drug alendronate, which was used to medicate osteoporosis. The manufacturers attempted to extend their patency protection by stating that a new version of the drug had been created, which reduced side effects and changed the way it was administered. Section 18 of the Patents Act requires for a new patent to have a level of inventiveness or a new method of manufacturing. In his decision, Justice Giles found that the follow-on patent did not meet either of these requirements. Now, despite negative media attention during the introduction of the Australia and US Free Trade Agreement, pharma companies have been able to apply to extend their patent protection by up to 5 years in Australia since 1998, with the introduction of the Intellectual Property Laws Amendment Act of 98. Section 70 of the Patents Act outlines the criteria for an application to extend a patent beyond the standard 20 years. Essentially, the court, upon receiving an application for extension, would be required to determine whether an extension was for pharmaceutical substance per se or due to the use of recombinant DNA technology. Now, in 2004 and 2005, there was quite a lot of discussion surrounding the Australian-US Free Trade Agreement and how it would make evergreening a common practice in Australia. People were worried about the impact the agreement would have on Australian legislation, in particular the Therapeutic Goods Act. On your screen, you will see different concerns that had been raised in relation to the agreement. The first concern was how similar the provisions were to the Hatch-Waxman legislation introduced in the US. This infamous legislation was brought in 1984, and its purpose was to increase the access to medicines. In reality, however, this legislation led to increased litigation surrounding generic medicines being brought to market, and it kept drug costs at a high. The second comparison was to the NOC regulations in Canada, which meant that generic manufacturers would have to notify the patentee of their intention to replicate upon the conclusion of a patent term. They would also have to apply to the health minister. The process could take up to 24 months for approval, and again resulted in high drug costs as generics entering the market were delayed. As a requirement of entering the Australian-US Free Trade Agreement, Article 7, 10 and 4 stipulates that the Therapeutic Goods Act create a process whereby patent holders were notified of the intention of generic manufacturers to recreate their product, and that their marketing approval on safety and quality grounds be prevented where there was a competing product claimed. Now, people were concerned that changes to the Therapeutic Goods Act would allow for US pharma companies to use the Australian judicial system to extend their patent life protection, essentially opening the door to evergreening. Cases such as the Novartis case in India, Bayer's case, Pfizer, all seemed a likely result of joining the agreement, preventing generic medicines from entering the market. So the TRIPS agreement. This agreement was introduced under the World Trade Organization to protect intellectual property rights globally through its member countries. In 2001, the Doha Declaration came to fruition after discussions with many of the developing nations under the TRIPS agreement. This declaration put public health and access to medicines as a priority for the TRIPS countries. Now, up until 2005, India would be in what is referred to as a transitional period for patent protection. India did not provide protection prior to this. The case of Novartis and India Union and others highlights this period well. In 1998, Novartis filed for a new patent for their drug. However, it was not until 2005 when India considered this application, and in 2006 controversially denied it. Their reasoning was, as Carla said earlier, that Novartis had attempted to extend their patent protection to maintain market share. This was under Section 3D of the Indian Patents Act. Now, evergreening remains a divisive topic amongst pharmaceutical companies, governments, and the general public. While a majority would agree that medicines need to be accessible and affordable, there are also many who would agree that creation of new medicines is equally important. While Australia has limited cases involving evergreening, in the case of Merck & Co. and Arrow Pharmaceuticals, Justice Giles and the High Court Justices on appeal all found fault where it was due. In the instance of Novartis and Union of India, the court took an issue with the level of inventiveness and also denied the patent application. Now, the cost of developing a new drug and carrying through the market is now estimated to be at $2.5 billion. This was a study done by the Tufts Study of Drug Development. With development costs exponentially growing over the past several decades, head of Norton Rose law firm, Patrick Kiernans, when asked to comment on the outcome of the Novartis case, said that bringing a new drug to market carries Vegas-like odds. Putting up barriers to protecting intellectual property will only discourage innovators from taking those risks. He also reflects on the statute of monopolies in the UK that recognised it is good for the economy to encourage people to take these risks and bring new things forward. It is a common goal of the TRIPS countries to provide access to medicine while also protecting intellectual property rights of innovators globally. Section 3D of the Indian Patents Act, Title 35 of the US Code, Section 156, the Australian Patents Act of 1990, Section 18 and Section 70, Article 17 of the Australia-US Free Trade Agreement, And Section 26C and 26D of the Therapeutic Goods Act are all examples of legislative measures put in place to prevent the exploitation of follow-on patents by pharma companies. As fellow law student Stephanie Crosby depicts in her article, it would be unrealistic to expect pharmaceutical companies to sacrifice their commercial interests for the greater good. In conclusion, the present legislation appears to provide fair terms for follow-on patents and hence discouraging evergreening. Thank you.
Thank you, guys. Nicely done. Very nicely done. I'll throw it open to your esteemed colleague so that you can ask some questions. Oslita, Annie, Jessica, Bianca, go forward. It's now grilling time, open season. Come on, Bianca, I can see you're itching. Nadine? Come on, questions.
That's good. Keep quiet.
Questions from the audience? No questions? Don't leave it to me, guys.
No, look, Jacob and I have to work on another time together on another subject, so I have to be nice to him.
Now you've got a taste and cringing, I know. I saw your email.
Oh, it's a bit of quid pro quo here. It's a bit of quid pro
Just give
quo.
me the smallest talking part and you guys will be right.
No one has any queries. All right, I'm going to ask some questions then, guys.
Sorry, AJ, before you go ahead, I just wanted to ask if anyone had any good ideas or thoughts about when not strengthening an IP system in regards to evergreening would be a benefit. As in not strengthening it. Yeah.
Benefit to who? Bianca.
Exactly.
Because there's two ways. There's two ways to look at this issue, and I'm pretty sure that I think Jacob is can answer it better than I can because he's the one that dealt with the controversy. But I think my point of view is better to who. The problem is, do we want what's better for the public good, for the average citizen, or do we want what's best for the pharmaceutical companies? So your question is a bit hard to answer. It has to have there's 2 points of view regarding this. Jacob, do you want to add something?
Just ask me the question again. I've got to think.
So what would be the benefits to not strengthening an IP system in regards to evergreening?
Can I jump in there and throw in?
That's right. I was actually going to say, I was thinking what Catherine said about how that Waxman Act was the intention of that was to allow generic drugs to become available when it increased litigation, and had the opposite effect and kept generic drugs quite high. So maybe generally it would be a good idea to keep drug prices down, to not implement an evergreening strategy or I'm not sure.
I think by being relaxed on evergreening would potentially mean that new ideas or innovations would come forward. They know that they're going to get the protection that they want by being able to apply for patents and extend the time they have that market share. So it could potentially work in their favour, creating jobs, but mostly new medicines.
Yep, and I would also.
If I can. Oh, sorry.
I would add to that, but I'll add to it after Carla because I don't want to preempt what she's going to say.
Okay, thank you. Sorry. I just want to invite everyone to see it from a different angle. I know that everybody is defending the average citizen, that we are entitled to low cost and affordable drugs. But if you want to look at the big picture, the problem with diseases is they're not in a halt. They're not stopped. New diseases are coming up every day. And the old diseases that we know are mutating and changing. And they require a new medication and a new approach and new types of molecules and drugs to actually control these drugs. So when we talk about the balance between the price of the drug and the money that the pharmaceutical company is benefiting from, we have to keep in mind that the profits of the pharmaceutical company is not taking all the profit and saying, oh wow, I'm rich now. They're investing some of that profit into research, into developing new drugs and new systems of delivery of old drugs in order to fight the new diseases that are emerging. I give, for example, the bird flu, Ebola virus, all these new drugs that we hear about on the news. If we put restriction, if we restrict too much evergreening, and we put too much, not only evergreening, if we put a lot of restrictions on drug companies and we sort of choke them, they're gonna withdraw a lot of the funding that goes into research and development. And that could affect the average citizen in a very, very bad way, because we won't have any new ways to fight the new diseases that are coming up. And the new diseases are more resistant to antibiotics, and the viruses are more mutated, more complex, more resistant to old-fashioned drugs. So it's not only about money and how much I'm paying for the drug. You have to see the big, huge picture behind it. Sorry, AJ.
No, I think that was very well said. And it was a necessary, I'm very glad that you brought that up, because I think it was a necessary adjunct to your presentation. I think there is, and in fact, I was going to ask you a little bit more about that if you didn't offer to do so, offer your information voluntarily. I was going to extract it from you, because I think often, much like biopiracy, this particular topic does get very hotly debated and sometimes emotively debated. And I think what everyone needs to bear in mind is that as much as people like to sometimes paint this issue as very black and white and tend to advocate very strongly in terms of patient access and low-cost drugs and whatnot, I mean, there are many, many shades of grey here. We're all law students and we make our money from shades of grey. So, it's important that everyone realise that these kinds of debates will be harnessed by a particular lobby interest group, and then they will be flogged, and often, unfortunately, to the nth degree, where the arguments don't necessarily stack up. So I'm very glad, Carla, that you've added that piece about, the ability of drug companies to keep funding their exploration of new drugs. And particularly we're seeing some fairly amazing new therapies coming on market. I mean, you've got the whole targeted genetic therapy area, which is just an incredible area that I'm sure will explode very shortly. And in order to sufficiently, perfect those technologies, it's going to take years and it's going to take billions of dollars. So that is a very important point that needed to be made. I'm very glad you made it. The other answer that I had for you, Bianca, which is slightly more jaded and cynical, is that if you actually don't try and tweak a country's legislation in order to deal with the evergreening issue, then it's going to make certain people very happy, and that's not necessarily just the drug companies, it is the US government, because our obligations under the US Free Trade Agreement were all fairly much stacked up in line with that dreaded Hatch-Waxman Act. So, you know, it was very much about big pharmacy rights, you know, big pharma being able to extract every dollar they possibly could out of their patent rights. And in fact, and correct me if I'm wrong, group, but the US trade representative really got ticked off by our amendments to our Therapeutic Goods Act, where they tried to minimise the opportunity for drug companies to abuse their way into evergreened rights. And in fact sent us a nasty little snippy letter saying that they reserved all of their rights in good legal jargon to query whether our amendments to the TGA were in fact in conformity with our obligations under the TRIPS agreement. So, you know, if we hadn't introduced those kinds of legislative precautions against evergreening, I'm sure the US government would have been very, very happy with us. As it stands, I think that issue has blown over because there hasn't been a whole lot of action under those provisions of the legislation from what I can see. Group, correct me if I'm wrong. I'm of course talking specifically about sections 26C and 26D of the Therapeutic Goods Act, which deal with, the requirement for drug companies to provide a certificate if they're going to go ahead and try and sue a potential generics manufacturer before they come on market in order to delay the entry of the generic drug onto the market. They have to provide a certificate that that the action will be commenced in good faith. And I think they also have to give notice to the Attorney General so that the Attorney General can be joined as a party to the action. And, you know, those kinds of provisions certainly got up the US government's nose, but I don't think there has been much action on those provisions, if I'm right. Perhaps they've had a decently deterrent effect.
Yeah, I couldn't find really anything relating to it yet. No cases on it, yeah.
No, I think really it was a shot across the bow, just to warn everybody that, you know, our legislation was not going to go down the same road as Hatch-Waxman. As you rightly pointed out, Hatch-Waxman started off with a whole heap of good intentions and some provisions that were meant to facilitate generics entry into the market. What unfortunately happened was you had this whole series of amendments as a result of big pharma's lobbying and progressively restricting the original intent of the Act to the point where now it actually works in pretty much the opposite way than what it was intended to work. So an interesting little side note there. Do you have any other queries? Annie, Nadine, Jessica. Thank you, Bianca, for your thoughtful question. Joselito, any thoughts? No, you're good? All righty. One thing I will ask you, group as a whole, and feel free to jump in. You tended to focus on evergreening by way of follow-on patents for relatively questionable developments of the originally patented formulation. what do you guys think about the whole kind of perhaps more seedy underbelly of evergreening, where you've actually got no real change to what's been patented, but you have this very aggressive stance by big pharma companies threatening to litigate the potential generics manufacturers and trying as hard as they possibly can to scare them away by every other means available apart from the whole patent system. So just litigate. What's your comment on that?
It is a strategy used by drug companies when they are faced with a situation where they cannot, where the patent is, it got to a point where it's close to be expired, and there's no way for them to renew that patent or to seek an evergreening way to modify the molecule in a way to extend the life of that patent. It has been done before. It's been also done in Australia in a case, I can't remember the name of the drug, I'm sorry, because I read it a long time ago. But it was unsuccessful in Australia. But in the USA, it's very successful. They bully the other companies into submission, if you want. And just because they're multi-billion dollar companies, they take a stance that we can afford to have a lengthy litigation, but you can't.
Absolutely. And that kind of strategy of drawing things out by way of threatened litigation, commencing litigation, going slow on the litigation, all those tactics will add up to added months and years of protection, really, won't they? Because for every month that litigation is proceeding, they're delaying entry. So, and as you will have read in your materials, I mean, for every month that goes by of delayed entry, it can cost millions of dollars, maybe billions. So I think it is a strategy that I think that's why we in the TGA introduced those provisions about a good faith certificate, just to nip that whole process in the bud. The other thing I wanted to ask you guys about was the notion, and I don't, correct me if I'm wrong, but Carla, you mentioned that the Gleevec patent in India was rejected. It failed the whole notion of better efficacy. And you mentioned novelty and inventive step, and somebody else mentioned the issue of inventive step. Oh, Jacob, you mentioned Section 18 in our legislation. And Catherine, I think you mentioned Title 35. All of these comments were kind of dancing around the issue of inventive step, and I would have liked to have heard one of you guys perhaps expand on the notion of inventive step, because the Productivity Commission's recommended reforms in their IP arrangement report specifically talk about the whole issue of inventive step in Australia not being high enough, and that if the Gleevec, well, the Productivity Commission don't talk about it, but there's other articles out there that talk about it. If the Gleevec case happened here, under our notions of inventive step, which are a lot lower, it may well have snuck through. What's your take on Australia's current position on inventive step, and do you think it needs to be raised? Oh, and the other thing, I hate to do two questions in one, but I know that someone's going to go take the ball and go running. So the other question was, in that Productivity Commission report, they specifically talk about scrapping that extra 5 years worth of extension for pharmaceutical patents. And the only way that you would be able to get that extension would be if there was a, quote, unreasonable delay by the TGA in approving your pharmaceutical to get out to market. So firstly, can you just talk about inventive step? And secondly, just talk about that whole issue of that 5-year extension.
Look, I realised from reading my thing that I didn't know enough about that, about the inventive step and how it actually works. And I realised that was a sort of a big shortcoming of my paper. And I only wrote very generally about the Merck case, describing about an inventive step in follow-on patents, where initially when I started reading about it and trying to understand it, I thought, oh, all they have to do is increase the dosage or find a new delivery system, and that's sufficient. But I don't think it was sufficient. They tried that in the Merck case and it wasn't. And I was just still trying to get my head around the concept of it. And I was talking to Carla about, I think, the active pharmaceutical ingredient, the molecule they make, actually has to be changed or something like that. But to answer your question, I haven't got enough knowledge to go into depth.
That's okay.
I do, actually. I have a bit of knowledge about it. I just wanted to give a chance to the other members of my team to answer.
I just wanted to
answer. I will answer you, AJ.
Sure.
Do I answer?
Catherine, did you want to chime in, or Brendan? Just on the issue of the inventive step, do you think it's sufficiently high here, or do you think it should be changed?
From what I've looked at, I think it's sufficient, but I haven't looked into it enough. I'm with Jacob.
Okay.
Yeah.
Brendan?
Yeah, I think it's good enough. But like in the Lohmann therapy systems case, the actual bandage and that seemed to be a really good idea, but because it didn't have the actual change to the substance, it wasn't put through. The extension wasn't granted. Where it sort of, in a way, hold back from that sort of inventiveness if they're not going to put things through like that.
Yeah. So did they, in that particular case, was there some reason why they didn't just apply for a patent for that invention on its own? If the take...
No, I think the actual thing wasn't inventive by them, but using it with that drug and releasing it slowly was a much better way of doing it.
Right.
Whereas there was another case, I can't find it here, where a similar thing, when it got to the court, they finally put it through and accepted it. But they didn't appeal that case, which passed the patent office. They just went to the patent office and didn't get it.
Yep.
Extended, and after that they just left it, I think.
Gave up. Yeah.
Yep.
Yeah. Probably ran out of money.
Yeah, it's normally the way, isn't it?
Yes. Carla, did you want to jump in?
Yes. I'm sorry. I have to disagree with my with other members of the group. I think it's not high enough. The issue, okay, the modification of the drug molecule, it has to be a substantial modification. The drug company has to show a huge change in therapeutic efficacy. And when we talk about therapeutic efficacy, we start talking about pharmacokinetics, which not only involves a different delivery system, but also a faster absorption, faster, maybe slower metabolism of the drug molecule inside the body. For example, with the imotinib mesylate, the addition of mesylate into the imotinib molecule, it gave it characteristics, more characteristics. It could be used to fight rheumatism and to fight other diseases, other than only to be specific for cancer. and it enhanced the therapeutic efficacy, but not a lot, not by a lot. And the mode of action on other diseases was not very significant to be considered as a new drug that should be entered into the market. For example, I give another to be clearer, because I know it sounds like a bit of mumbo jumbo for someone who doesn't come from a pharmaceutical background. For example, the molecule Viagra, when it was first invented, it was invented as a cardiac drug, a drug for cardiac disease, and specifically to decrease the high tension, hypertension. And after a while, it was discovered that it has efficacy on, you know, maintaining erection with the male. So it was patented again as a drug who is specific for erectile dysfunction. And this is the kind of, in my opinion, my humble opinion, this is the kind of example of what it should take for us to consider a drug as patent, as, you know, as good to be patented as another molecule, and not just, you know, if I take the tablet, instead of having, you know, instead of being absorbed in my blood in 5 minutes, it will be absorbed with 3.5 minutes. It's not enough. This is, or for example, instead of staying in my body for 6 hours, it stays for 4.5 hours. It's not enough. And unfortunately, here in Australia, I think the test is so low that drug companies are taking advantage of this in order to extend the patent of their drugs. But I don't know, that's my opinion anyway.
No, it's very good that you mentioned that, because you know, the test here, as you guys will all know, is that inventive step requires that it not be obvious to a person skilled in the art. And when you're talking about something not being obvious, the sub-test for that is that there has to be a scintilla of inventive step. So that's teeny tiny speck. I mean, that really is a very, very low threshold. And I think this is where Carla was going. You know, if you're going to be talking about awarding, you know, fairly significant patent rights over something, I mean, let's face it, patent rights are probably the strongest of all the IP rights. I would agree with the Productivity Commission and say, come on, guys, you know, lift your game and get something, get a test in place that actually requires a decent level of inventiveness. And I think that would go a long way towards discouraging the whole evergreening issue here. Carla, I appreciate your your comment on Viagra. What that was, though, was it's and I don't at all expect you guys to understand this, and we'll wrap up just very shortly, but so where you've got evergreening, generally speaking, it is the pharmaceutical company fiddling about with that original formulation of the drug and tweaking it and getting on with business, trying to get a new patent for that. Viagra was what we call a new use of a known medical substance, and TRIPS actually requires us to grant patents in that situation. So perhaps a little different to just tweaking a formulation, but I appreciate your comment because it was intended to support your notion that perhaps inventive step could be raised, and I certainly agree with that.
Hey, AJ.
Yes.
Do they have like an evergreening thing for stuff, extending patents for stuff other than drugs? Because like I went to this hospital to get my liver checked, right? And I had to go to Nambour from Bundy because they had this machine there that they don't have here in Bundaberg. And when I was there, I was looking at the machine, and all it does is test the density of liver. But the nurse said, when I was asking about it, she said originally the machine had been repurposed. It was originally developed in France, or invented in France, to measure the density of cheese. And it didn't work well. It didn't work well for that purpose. So they worked it out to do the liver, right? And I was like, oh wow, because it looked like a parking ticket vending machine, an all-purpose machine, microwave oven and a clock. And I wondered, is there a similar thing with inventions that get repurposed? Is that like an evergreening thing? Can you get an extension of a patent there or something?
Not that I'm aware of, although there is a whole separate section in the TGA. There's a whole separate regulation for medical devices.
That thing you were talking about before, recommendations, lifting the bar and stuff for the requirements on patent requirements. Productivity Commission, is there a name for the report or something, if I wanted to look it up?
Yep, it's linked in the week, I believe it's the week 7 materials on IP reform.
Okay, thanks.
That was the main reading for that week.
Okay.
It's Productivity Commission, and the name of the report is Intellectual Property Arrangements.
Thank you.
Yeah, that's probably. Oh, the only other kind of exclamation mark at the end of Carla's last comment in relation to Viagra was, there's also lots of juicy trademark cases around that particular drug as well. And there was, obviously Viagra was registered in China, but no one wanted to call it Viagra, so everyone started calling it Big Brother. And then someone tried to nick the trademark for Big Brother, and Viagra tried to stop them, and they got up because they, no pun intended, because they said that in China, the bulk of the population was used to calling the drug by the name Big Brother, and when they said that, they intended to be buying Viagra. So it would be confusing to the public if another manufacturer supplied to the market under the name Big Brother. So there you go, a little bit of trademarks thrown in. Thank you very much, guys, for your presentations. I really do appreciate it. If you guys want to stay back for like a 1-minute wrap up with me, that would be great. Thank you to everybody else that has attended. I really appreciate it. Thank you for your erudite questions, as always, Bianca. And with that, thanks again to everyone, and good night. I'll stop the recording.